The Arthrex case is a fascinating case that lies at the intersection of technology policy on the one hand and separation of powers questions on the other hand. It seems to address the question whether the administrative patent judges who staff the Patent Trial and Appeals Boards are inferior officers or principal officers pursuant to the Appointments Clause of the Constitution, which sets forth different requirements for appointing those two types of officers. Arthrex owns a patent which is directed to a knotless suture securing assembly, and one of its competitors, Smith & Nephew, filed a petition requesting what's known as inter partes review before the PTAB of some of the claims within that patent. The Appointments Clause is a provision within Article 2 of the Constitution, and it authorizes certain officers who are known as principal officers to be appointed to their positions by the President and with the advice and consent of the Senate. It also spells out that other officers who are known as inferior officers may be appointed either by the President with the advice and consent of the Senate, or alternatively, may be appointed by the President alone, by the courts of law, or by the head of a department. The case turns on several precedents that the court has decided that draw the line between these two types of officers. The first case is a case called Edmund versus United States. It was decided in 1997, and it spells out what might be described as a two-part test for drawing that line between inferior and principal officers. Does somebody else within the executive branch, between the President and the officer who's at issue, have the authority to remove that officer? And does somebody else within the executive branch have the authority to supervise that officer's decisions? It's never been quite clear whether both of these prongs are necessary or one is sufficient. The second case is the famous case of Morrison versus Olson, which addressed the constitutionality of the removal provision that protected what was known as the independent counsel from removal by another officer within the executive branch. The court in that case said, for a variety of reasons, adopting what might be described as something of a multi-factor test, that the independent counsel was in fact an inferior officer. The United States government argues that the PTAB scheme does not violate the Appointments Clause at all. And they argue in a nutshell that applying the two-part test that I mentioned that derives from Edmund versus United States, the PTAB judges are in fact supervised by officials within the Patent and Trademark Office in a variety of ways and can be removed for cause if necessary, and as a result, that makes them inferior officers. Arthrex argues that PTAB judges are not inferior officers. By statute, decisions of the PTAB with respect to the patentability of claims in a patent are appealable to federal court, and they're the final decision of the executive branch. So with respect to specific adjudications, decision-making is lodged, at least pursuant to statute, solely with those judges of the PTAB who are deciding with respect to a particular patent. The Federal Circuit decided that, in fact, the PTAB judges were unconstitutionally appointed because, according to the Federal Circuit's decision, the PTAB judges are principal officers, not inferior officers, and must be appointed with the advice and consent of the Senate. The Federal Circuit then remedied the constitutional violation that it identified by severing from the statute the provision that protects PTAB judges from dismissal for cause. Arthrex says that the Federal Circuit can't rewrite the statute governing the PTAB. Instead, there's a constitutional problem, and that constitutional problem will remain until Congress revisits the statute and creates a different mechanism, either for creating the PTAB judges as true inferior officers, or alternatively, making them principal officers.